Hello and welcome to the Minimum Competence episode for Thursday, March 12th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, Live Nation antitrust trial stalling amid settlement fights, ExxonMobil's move to Texas, and a £5 billion class action accusing Sony of locking in PlayStation users in the UK. Let's remember, freedom in a republic is not the reward of a party, it's the inheritance of every citizen. And read today's legal news. On this day in legal history, March 12, 1804, the U.S. House of Representatives voted to impeach Supreme Court Justice Samuel Chase. Chase, a Federalist appointed to the court in 1796, had become a controversial figure during a period of intense political division between the Federalists and the Democratic Republicans. Members of Congress accused him of allowing his political views to influence his conduct on the bench. Much of the criticism focused on Chase's behavior during trials brought under the Alien and Sedition Acts, where he was alleged to have treated defendants and their lawyers unfairly. The House approved several articles of impeachment claiming that Chase's courtroom conduct showed bias and undermined the impartial administration of justice. The impeachment moved to the Senate for trial in early 1805, with Vice President Aaron Burr presiding over the proceedings. After weeks of arguments and testimony, the Senate failed to reach the two-thirds majority required for conviction on any article. As a result, Chase was acquitted and remained on the Supreme Court until his death in 1811. The outcome established an important precedent about the limits of impeachment as a tool against federal judges. Although Congress has the constitutional authority to impeach judges, the Chase trial suggested that impeachment should not be used simply because legislators disagree with a judge's legal or political views. In the years that followed, the case came to symbolize a commitment to judicial independence within the federal system. By declining to remove Chase from office, the Senate reinforced the idea that judges should be protected from political retaliation for their rulings. The episode remains the only time a sitting Supreme Court justice has ever been impeached by the House of Representatives. Today, the Chase impeachment is often cited in discussions about the balance between judicial accountability and the need for an independent judiciary. A federal antitrust case against Live Nation Entertainment has stalled as negotiations over a proposed settlement continue and several states resist the deal. The lawsuit, brought by the U.S. Department of Justice Antitrust Division and numerous state attorneys general, alleges that Live Nation used monopolistic practices to dominate the live concert industry after acquiring Ticketmaster in 2010. During a recent court hearing, Aaron Burr criticized both sides for failing to notify him earlier that settlement discussions were underway. He said the parties waited until just before trial to reveal that negotiations were close to completion, which he suggested was improper conduct. The proposed settlement would require Live Nation to allow competitors to sell tickets at some of its venues, limit certain ticket service fees to 15%, sell control of at least 13 amphitheaters, and loosen exclusivity arrangements. The company would also create a settlement fund exceeding $280 million to resolve state claims. However, attorneys general from many of the states involved have objected because the agreement does not require Live Nation to divest Ticketmaster. More than 24 states have asked the court to declare a mistrial and restart proceedings later, though others support or are still evaluating the settlement. Judge Subramanian has not yet ruled on the mistrial request and instead urged the parties to continue negotiations immediately at the courthouse. He indicated that if a broader agreement cannot be reached soon, the court will determine the next procedural step. Live Nation maintains that the industry remains competitive and argues that the plaintiffs have selectively used data to support their allegations. The dispute highlights the complexity of resolving large antitrust cases involving both federal and state enforcement authorities. ExxonMobil has announced plans to move its legal incorporation from New Jersey to Texas, citing the state's increasingly business-friendly legal environment. In a proxy statement to shareholders, the company explained that most of its senior leadership and corporate functions have already been located in Texas for decades, making the change largely formal rather than operational. Executives said Texas offers a more predictable, statute-based framework for corporate governance and regulation. A major factor behind the move is the creation of the Texas Business Court in 2024. Exxon also pointed to recent updates to the Texas Business Organizations Code that clarify standards for corporate decision-making and director conduct. Company leadership believes these reforms create a legal climate that supports economic growth and shareholder value. Exxon joins other companies that have relocated their corporate domicile to Texas, including Tesla and Coinbase. State officials have promoted these moves as evidence that Texas is becoming a strong alternative to traditional corporate hubs such as Delaware. Recent reforms include legislation codifying the business judgment rule, which limits liability for corporate directors unless misconduct like fraud is proven. Texas has also launched broader initiatives to attract corporations, including approval for the upcoming Texas Stock Exchange, expected to begin operations in 2026. Supporters argue these efforts strengthen the state's reputation as a center for corporate formation and governance. Exxon's relocation reflects this broader trend of companies seeking jurisdictions with legal systems designed to favor corporate decision-making and reduce litigation risk. Or oversight. It all depends on how you look at it. Millions of PlayStation users have begun a major antitrust class action in the United Kingdom against Sony Interactive Entertainment, seeking about £5 billion in damages. The case is being heard before the Competition Appeal Tribunal and is expected to last around 10 weeks. The lawsuit is led by consumer advocate Alex Neal, who represents millions of PlayStation customers. The claim alleges that Sony unlawfully controls the digital PlayStation ecosystem, limiting competition and forcing users to buy games and add-ons only through the company's online store. According to the plaintiffs, Sony pre-installs the PlayStation Store on its consoles and prevents users from installing alternative software or accessing other digital marketplaces. As a result, consumers allegedly become locked into Sony's platform and cannot shop for cheaper options. Lawyers for the consumers argue that these restrictions allow Sony to charge higher prices and maintain strong profit margins. A major issue in the case is how the relevant market should be defined. Sony plans to argue that its consoles and digital services operate as a single part of a single systems market, where hardware and software function as one integrated product. The plaintiffs disagree, claiming the console is only the initial purchase and that digital games and add-ons form separate aftermarkets where Sony exercises additional control. They argue consumers often cannot predict future costs for games or downloadable content when they buy the console, making them vulnerable to higher prices later. Sony is expected to argue that it simply created a platform that enables game publishers to sell products efficiently and that it is entitled to control access to its storefront and intellectual property. The company maintains that these practices are legitimate business decisions rather than anti-competitive conduct. The tribunal will ultimately decide whether Sony's control of its platform amounts to unlawful market dominance under UK competition law. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We would sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the cause of freedom is not the cause of a section, but the cause of humankind.